So here in court A appearing should be team 101 as applicant, who I see and they have their cameras on. If you can just wave so that I know that you can hear me. Okay, great. I can see your wave. And then we have team 105 appearing as respondent. Okay, I see your waving as well. But I see that it's also the provincial coordinator and not the team. So I just want to identify from which account the team is. So I'm going to ask that team to start their video. I've sent a request. Okay, there, I see you now. Can you just wave to ensure we can hear you? You can hear me? All right, great. So I have our applicants ready. We have our respondents ready. Everyone else's mics are muted and everyone else's cameras are off as it should be. I'm going to remove 109 as this is not the room that you should be in. As we only should have, we should only have 101 and 105 as per the rules. So I'm removing anyone with the team number that does not correspond with this. And if Justice Bum, you could just assist me with this in case there's someone I miss.
That's fine.
Thank
There's,
you.
there's someone.
Justice Nyamadi?
Yes?
Team 109 should be in courtroom B.
Okay, okay.
You
so I'll just let them know.
You have removed them from your courtroom. They should use the link for courtroom B.
Court B. Yes. Okay, that's fine.
Yeah, please advise them.
Yes, so I'll just send a message as well. I'm not sure who this person is now, you see. Okay, let me just admit and maybe ask a question as to which team they're associated with. All right. All right, to the teams, I hope that you're ready and that you are as calm as is possible. This is an exciting journey and you should take it as a learning opportunity and an opportunity to also grow yourselves. So don't worry, we are here for your success as the judges of this bench, and we want to ensure that you do well. So when we engage you, it will really just be to make you grow and to also just make this experience as exciting as possible for you. So welcome to your first round. My name is Justice Nyamadi, Matikomborera Nyamadi. I'm with the Center for Human Rights, and I will be the presiding judge in this round and in this courtroom. So the basic rules, we will have, the rest of the courtroom will have their cameras and mics muted as you speak. You are welcome, for example, the respondent is welcome to keep their camera on as the applicant delivers their arguments, but please remember to keep your mic muted. And the same goes for the applicant, that whilst the respondent is presenting their arguments, you're welcome to keep your camera on, but please switch off your mic or mute your mic. So the first thing that we're going to do is introductions. So the applicant is going to, the first speaker for the applicant will introduce the applicant speakers. And then pursuant to that, they will let us know how much time they'll be using. I will then be timing from my end, and I'll be switching on my camera and putting a piece of paper in front of the camera like this to indicate how much time you have left. So this piece of paper that I will indicate will have the number of minutes that you have left. And this is how we will proceed. So if there are no initial questions, any questions from the learners, any questions in the courtroom? All right, I see there are no questions. So we will welcome the first speaker for the applicant to do introductions, and then you can proceed with your submissions. Hold on, there's something wrong with your mic connection. Could you mute and unmute? Because I can see that you're talking, but we cannot hear you. Yes, we still can't hear you. Okay, whilst the applicant is still trying to sort out their mic, respondents, could you just unmute yourselves and just say good morning so we know that you don't have the same problem? Okay, maybe this is a me problem. Can anyone else hear them?
I cannot hear them, but I can hear you on my end, Mati. Thank you.
Okay. Maybe let's try.
I can also hear you.
Yeah.
I can't hear them though.
Okay.
In Supporter 101, are you with the team where you are, the applicant team?
No, I'm in a different, I'm in a different town altogether. I'm not with them, but I'm gonna try and text someone who's there with them.
Okay, thank you very much.
Sure.
Okay. Team respondent as well. I see you are now unmuted, but still we cannot hear you. So maybe if we could perhaps ask the team to maybe leave the Zoom meeting, try and rejoin so as to reconnect your audio, and then we'll try that way. Maybe that will give us a quicker solution to our problem. Applicants, whenever you think that you've sorted out your mic issue, please just say something and then we'll let you know if we can hear you. Yes, we can now hear you. Is it possible for you to speak standing up so that when you speak louder, we can hear you? Because we can hear that there's sound, but the sound is quite low. Just tell us your name.
As the court pleases, I am Liteta Jongwe, together with my co-counsel, Mission Paswa, appearing on behalf of the applicants.
All right, thank you. You can take your seat whilst we try and see if the respondent has also sorted out so that they can hear you too. Okay, I see here's the respondent now. Good morning, respondents. Can you hear us and can we hear you?
Yes, we can.
Okay, great. And I can hear you as well. Okay, you're welcome to mute your mics. Yes, okay. So I'm going to spotlight our applicants. All right, applicants, once you're ready, you may begin.
If it pleases the court, as the counsel for applicant, I'll be using 10 minutes of the court's time, and my co-counsel will be using 8 minutes, and we reserve 2 minutes for rebuttals. If it pleases the court, as the counsel for applicant will be addressing two issues. Issue one, that Section 4 of the School Code of Conduct contravenes the provisions of Section 29 and Section 14 of the Constitution of South Africa. My co-counsel will address issue 2, that the SGP's decision to suspend the learners is unconstitutional, as the learners were merely exercising their rights to peaceful assembly in terms of Section 17 of the Constitution of South Africa. Your Justices, as the counsel for applicant, we introduce Section 2 of the Constitution of South Africa. This section states, this Constitution is the supreme law of the Republic. Law or conduct inconsistent with it is invalid, and the obligations imposed by it must be fulfilled. Your Justices, Section 29 of the Constitution of South Africa, subsection 1, states that everyone has the right, subsection A, to a basic education, including adult basic education. Your Justices, as the counsel for applicant, we submit that by being suspended, this is a violation of the applicant's rights to basic education, as the applicants will not be able to gain access to the school, which is the place where they can exercise their right to basic education. To support this, your Justices, we quote from case Moko versus acting principal of Nsmcc Secondary School and others. In paragraph 35, it was stated that, and I quote, access to a school is a necessary condition for the achievement of the right to basic education, close quote. Your Justices, as the counsel for applicant, we submit that By being suspended, the learners will not be able to gain access to the school, and they will not have that necessity or that necessary condition to allow them to exercise their right to basic education as detailed in Moko versus Acting Principal of Malusi Secondary School. Furthermore, your justices,
I hear what you're saying towards the argument that we should be able to allow them to access school so that they can access their basic education. But don't you think that a better solution would be for them to have homeschooling and just access education that way? Why do they need to, in essence, be at school or access the school premises?
As it pleases the court, in this case, your justices, the applicants are actually starting at a public school, which means the resident public school may be, your justices, that they do not have the appropriate funds to fund for private tutors or homeschooling, as it pleases the court.
You may continue, counsel.
Furthermore, your justices, if it pleases the court, the counsel for applicant introduces section 28 of the Constitution of South Africa. Subsection 1 of this section states that a child's interests are of paramount importance in every matter concerning the child. Your justices, we submit this right is unambiguous. Did the suspension prescribed by section 4 of the School Code of Conduct put the child's interest first? Your justices, as the counsel for applicant, we submit to this honorable report that the school did not put the child's interest first. It did not consider the negative impacts and the trauma the applicants will have during the suspension, as the applicants will be behind on their academic work, as they will not be able to exercise their right to basic education. Since your justices, they are going to be behind on their academic work, this will further affect their future, as that small curriculum that was missed will further affect them in the exams. The justices, if it pleases the court, the counsel for applicant course of deliberations made in MEC of Education, KwaZulu-Natal, and others, versus Pillay, paragraph 98. It states, and I quote, both discipline and education are legitimate goals. However, care must be taken not to state the school's interests too broadly, close quote. Your justices, as the counsel for applicant, you submit that the school stated its interest of having a free cell phone area too broadly and do not consider the lingering side effects the suspension will have on the learners. Your justices will submit that in this case, the applicant's rights to basic education were limited in an unjust manner. The school could have, to punish the learners, exercise less restrictive measures without having to exercise the more restrictive measure, which was to suspend the applicants. These less restrictive measures, your justices, could include a detention, calling on a parents' meeting to discuss this issue, without having to go on to the more restrictive measure, which was to suspend the learners, as this more restrictive measure will result in the applicants missing that opportunity to gain access to the school, which is the place where they can exercise their rights to basic education. If it pleases the court and there are no further questions, your justices, I will now proceed to address the second argument. This second argument will be split into two sub-arguments. Sub-argument one, that the search and seizure of the applicant's possessions without a warrant was a violation of the applicant's rights to privacy. For this argument, we rely on section 14 of the Constitution. The second sub-argument is that the manner in which the school conducted its search without a warrant was in violation of Government Notice 1040 in Government Gazette 227 of 12 October 2001, and as amended in terms of Section 61 of the Schools Act, which deals with safety measures in public schools. Your justices, Section 14 of the Constitution of South Africa states that everyone has the right to privacy, which includes the right not to, subsection A, have their persons or homes searched, subsection B, their property searched, subsection C, their possessions seized. Your justices, as the counsel for applicant, we submit to this honorable court that the manner in which the school searched and seized the applicants of their possessions without a warrant was a violation of this right. To illustrate this, your justices, we quote from Gartha and others versus Minister.
Are you saying that for a school to discipline students, they must get a warrant to do that? Because I am not getting your point clearly.
The Justice, in this case, we submit that the manner in which the school conducted its search and seizure of the applicant's possessions without a warrant was unconstitutional. To illustrate this, Your Justices, we quote from the case of Gartha and others versus Minister of Finance. In paragraph 69, the court held, and I quote, exceptions to the warrant requirement should not become a rule. A warrant is not a mere formality. It is a mechanism employed to balance an individual's rights to privacy with the public interest in compliance with and enforcement of regulatory provisions, close quote. Your Justices, in this case, the absence of a warrant meant that the school violated the applicant's rights to privacy. The school could have prevented that violation by issuing without a warrant to the learners, the Justices. If it pleases the court. Secondly, Your Justices, the respondent may argue that the search was supported by Government Notice 1040 in Government Gazette 227 of 12 October 2001, as amended in terms of Section 61 of the Schools Act, which deals with safety measures in public schools. Your Justices, Schedule 4, Subschedule 3 of this schedule states that a police official, or in his absence, the principal or delegate, may search without a warrant. This schedule goes further and states that this law only applies when there is reasonable suspicion that there is a dangerous or illegal substance possessed by such learner. Your Justices, the Gazette in this case defined an illegal substance as any unlawful, intoxicating, or stupefying substance. Your Justices, as the counsel for applicant, we humbly submit to this honorable court that cell phones do not fit into this definition, as cell phones are neither intoxicating nor are they stupefying. Therefore, Your Justices, in this case, it was unjust for the applicants to search. It was unjust for the respondent to search the applicants without a warrant because cell phones do not fit into the definition given by the Gazette, which permits a search without a warrant, as cell phones are not intoxicating nor are they stupefying. In summation, for all mentioned above, if it pleases the court, the counsel for applicant humbly requests that Section 4 of the School Code of Conduct be deemed as an unconstitutional measure as it violates the applicant's rights to basic education and privacy. If it pleases the court and there are no further questions, I will now hand over to my co-counsel to address issue 2.
Thank you so much, counsel. Thank you for your submissions, and thank you for effective time management. I don't think my learned brothers and sisters have any questions, so you may take your seat and hand over to your co-counsel.
It pleases the court to remind the court, my name is Nsmcc, counsel appearing on behalf of the applicants to deliberate on the second issue, that is, the SGB's decision to suspend the learners is in violation of their right to peaceful assembly in terms of Section 17 of the Constitution. Your Justices, as counsel for applicant, we submit that the applicant's rights to peaceful assembly in terms of Section 17 of the Constitution have been violated. Your Justices, 6 learners held a peaceful assembly outside the school gates to demonstrate against the unfairness of their suspension. This demonstration quickly turned into a gathering. They were merely exercising their right in terms of Section 17 of the Constitution. Section 17 of the Constitution states that everyone has the right, peacefully and unarmed, to assemble, to demonstrate, to picket, and to present petitions. This right also goes hand in hand with the right to freedom of association, which is under Section 18 of the Constitution. It states that everyone has the right to freedom of association. It is this right to freedom of association that made the demonstration into a gathering. Furthermore, in Part 3 of the United Nations Convention of the Rights of a Child, CRC, Article 15, it was stated that subsection 1, states parties recognize the rights of a child to freedom of association and to freedom of peaceful assembly. Your Justices, as counsel for applicant, we submit the applicants.
I have a question for you. I understand the need for us to really allow these children to access school, but much in the similar way that I posed to your co-agent this question, I want to understand why it is not justified for us to apply Section 36 to this situation and, really bring to resolution? Because, I mean, your co-agent brought up the issue that we must be able to, put the best interest of the child forward. But what about all the other children in the school? So why should we not be applying Section 36(1) of the Constitution in this instance?
As it pleases the court, may I please consult with my co-counsel?
If you don't know the answer to the question, you can ask for clarity, or you can just state to the court that you are not aware of the answer of the question and will consider this and we can proceed.
As it pleases the court, may you please clarify your question?
My question is premised on why is Section 36(1) not applicable to this particular instance? So maybe can you help the court to understand why we shouldn't be applying Section 36(1)? And now you also have 5 minutes left.
As it pleases the court, Your Justice, are you referring to the right to basic education and privacy or the right to peaceful assembly?
All of the rights, counsel. Why should they not be limited? Maybe let me clarify that Section 36 of the Constitution, or rather 36(1), is the limitation clause. So my question is hinged on why should we not be applying the limitation clause, because these rights are not absolute rights. So why should we not be applying that? But of course, if you don't have the answer to this question, counsel, it's okay to just say so, and then we can carry on with the rest of your submissions.
Counsel, maybe I can also come in a little bit to provide clarity. So now, for every right, there is a limitation to it. Now, for the freedom of expression and assembly, there are limitations under Section 36. So what my learned justice is asking, why are we not applying these limitations to protect the general students? Why are you asking us to subject these rights only for the 6 students? Are they more important than the other learners in the school? Do you understand the question?
As it pleases the court, may you please clarify once more?
Agent, I think in the interest of your own time and for the interest of your case and the people you're representing, you can move on to the next point.
As it pleases the court, Your Justices, we submit that the applicants remained peaceful during the course of the demonstration. Therefore, it was unjust for them to be held accountable for the violence that transpired during the course of the demonstration. Furthermore, we submit that they remained peaceful because they did not damage any property or injure or cause any bodily harm. According to the Governor's case, at paragraph 53, it was held that an individual does not cease to enjoy the right to peaceful assembly as a result of sporadic violence or other punishable acts committed by others in the course of the demonstration if the individual in question remains peaceful in his or her own intentions. Your Justices, as counsel for applicant, we submit that no culprits were identified for the last 2 gatherings. Therefore, it was unjust for them to be arrested and suspended for these outbreaks of violence. Furthermore, Your Justices, as counsel for applicant, we submit that none of their assemblies can be classified as illegal gatherings. On the first gatherings, the learners convened spontaneously. Therefore, this knowledge exempts it as a gathering that would need a notice, as supported by Section 12, subsection 2 of the Gatherings Act of 1993. It states that it shall be a defense to a charge of convening a gathering in contravention of subsection 1A that the gathering concerned took place spontaneously. Your Justices, concerning the second and third gathering, we put into effect the Lungwana case. At paragraph 47, the court held that an assembly of 16 like-minded people cannot just be convened in a public space. The convener is obliged to give prior notice to avoid criminal liabilities. As counsel for applicant, we submit that the original conveners were lesser than 16. On the second gathering, there were only 6. To support this submission, in the facts, it was stated that 6 learners met up at Precious's house to plan a demonstration, and a demonstration of Justices we submit does not require a notice. On the third gathering, we submit that the original conveners were only 3. To support the submission, in the facts, it was stated that the police only read a message shared between 3 learners Eddie, Crystal, and Bali, who are the original conveners. Therefore, this qualifies the last two gatherings as a demonstration, which does not require notice. As it pleases the court, in summation of our issues, counsel for applicant submits to this court that Section 4 of the School's Code of Conduct is unconstitutional and in violation of the learner's rights to basic education in terms of Section 29 of the Constitution. It is also in violation of their right to privacy in terms of Section 14 of the Constitution. Concerning the second issue, your justices will submit that the SGP's decision to suspend the learners is in violation of their right to peaceful assembly in terms of Section 70 of the Constitution. If it pleases the court, as counsel for applicant, we pray for the following orders. Number one, that this honorable court set aside the order of the High Court. Number two, declare that Section 4 of the School's Code of Conduct is unconstitutional and in violation of the law. Number three, order the SGP to reinstate all the 6 suspended learners with immediate effect. Number four, we pray that the respondents must be directed to pay the cost of this application together with the cost of the two counsel. If it pleases the court, if there are no further questions, I thank you.
Thank you, agents, for the applicant. We have heard your submissions and we have taken them into consideration. Now, if we could have counsel on behalf of the respondents taking the floor, please. Remember to unmute yourselves. Respondent. Yes, there we go.
Can you hear me?
But there's a bit of a that are watching the proceedings. You need to mute the one device. So I would suggest that the other device that is not this one that you're watching us through, mute that other device so that we don't hear the echo. And then listen from one device.
Is that okay now?
What?
It's okay.
I don't mean mute your mic. So this sound, the sound of my voice should come out of one device. Therefore, everyone else should be listening either through earphones or through the sound of this device where you are hearing me. I hope this makes sense. Are you speaking? Okay, can we try again? Respondents? I think they're frozen. Okay. Respondents.
Can you hear me?
Yes, we can. Now we can hear you and we can see you. Is your network connection stable enough for us to continue on video?
Yes.
All right, that's fine. And there's no echo, so now that's sorted out. All right, we're ready when you are.
As the court pleases, I am Mafoto Motwani. I'm with my co-counsel, Matthew.
If you could just confirm how much time you'll be taking?
I'll be speaking for 12 minutes. My co-counsel will be speaking for 8 minutes.
Okay.
As the court pleases, I'll be focusing on the first matter, which is the constitutionality of Section 4 of the School Code of Conduct and whether it violates learners' rights to privacy and basic education. My co-counsel will be presenting on the second matter, which is the decision of the SGB. She will be presenting to the House that the decision was constitutional and does not violate learners' rights to education. Your Justice, the question before the court is whether Section 4 of the School Code of Conduct is unconstitutional and does it violate the learners' right to privacy and basic education. We submit that Section 4 of the School Code of Conduct is constitutional and does not violate the learner's right to right and basic education. Counsel for the respondent, therefore, will prove to this court that in line with Section 8 of the South African Schools Act and the case Head of Department of Education, Free State Province versus Harmony High School, and another 2014 Constitutional Court. Also the case Antoinette versus Governing Body, Settlers High School 2002 High Court, that Section 4 is constitutional. Your Justice, I would like to contextualize the case. In this beautiful country of ours, we have seen schools that have submerged in chaos. And from experience, we have learned that drastic disciplinary measures must be observed to transform the school. Some strategies may be unconventional, but they have proven effective, and non-educational factors such as cell phone has helped the learner to improve concentration and focus, and has also improved the results of the school. All this has been proven in general combined schools history. We do recognize that this digital platform makes learning easier, but it must be recognized that facilities and resources are afforded to students. We are referring to computer labs and tablets that are provided to a learner at a specific time. Your Justice, applicants say that the right to education is being violated. We say the right to education is limited because it provides the learners with education content, so it means it is a limitation, not a violation. Applicants also say a worry, but as respondent, we would like to side with SS Schools Act, which stipulates that all as drug-free zones, the principal of his or her delegate may do random search any group of learners of the property of a group learners if a fair and reasonable suspension has been established.
Counsel.
Your Justice.
Engage me. You are advocating that there is a limitation of the right to education.
Yes, Your Justice.
Is that correct?
Yes, Your Justice.
But there are no measures that you're putting in place to show that there is still benefit for these learners whose right you are limiting in such a way. Can you rather make it clear to the court why your limitation of their right to education is justified and exactly how it is a limitation and not a violation? I mean, it doesn't suffice to just address to the court and tell us that it is a limitation and not a violation when you're not really painting that picture clearly to show us this is how it is a limitation and this is how it is not a violation. So maybe just engage us on that point.
As the court pleases, it was obligated by the law. Your Justice.
Sorry,
Section 4
obligated to do what? To suspend the learners?
As the court pleases, can you just please repeat your question?
No, I'm just clarifying what you just said. You said that the school was obligated by law. Was the obligation to suspend the learners? I want to be clear on that point.
As the court pleases, no, it wasn't. Your Justice, Section 4 of the School Code of Conduct stipulates that the usage of cell phone, whether on or off by learners at school premises, shall at all times be prohibited. And any learner that is found in possession of a cell phone shall have that phone confiscated and may be suspended. Your Justice, to review whether this section is constitutional, we first need to recognize that this law was put into place because there was chaos and disorder at school. Because learners brought cell phones at school, which made them focus more on their cell phone than in class. We therefore defeating the purpose of the school. Your Justice, we submit that in terms of the South African Schools Act number 84 of 1996, we refer to it because all schools in South Africa are regulated in accordance with the Schools Act. We also refer to Section 8 of the Schools Act, subsection 1, which says that subject to any applicable provincial law, a governing body of a public school must adopt a code of conduct for the learners after consulting with learners, parents, and educators of the school. Subsection 2 stipulates that the code of conduct referred to in subsection 1 must be aimed at establishing a disciplined and purposeful school environment, dedication to the improvement and maintenance of the quality of the learning process. Your Justice, Section 4 aims at establishing a disciplined and purposeful school environment, dedicated to the improvement and maintenance of the quality of the learning process. Because it prohibits learners from bringing their cell phones at school. Because as we have previously noted, their cell phone causes distraction in class. We therefore argue that Section 4 of the School Code of Conduct is dedicated to the improvement and maintenance of the quality of the learning process, as it removes a factor that previously disturbed their learning process, which
Counsel.
shows that
Counsel.
Counsel, my learned colleague has a question for you. And my learned colleague, just allow me this before you ask your question. First of all, Counsel, you have 5 minutes left to your allocated time. And then secondly, I just want you to address the point of the best interest of the child according to the measures that you're taking. So now my learned brother will ask his question and then you can answer them both together.
Good morning, Counsel. Do you not suppose there are less restrictive means to achieve the same aim, or what is your take on that in light of the quite restrictive and peremptory provisions of Section 4? And on a balancing of interests, do you not suppose there may have been less restrictive means? And if you could address the court on that, please.
Your Justice, as the court pleases, Your Justice, can you please simplify your question?
Okay, in light of Section 4 saying that the ultimate punishment for even holding a cell phone is a suspension, do you not think that that is too extreme a provision, and perhaps it could have been less restrictive in the sense that maybe before a suspension there may have been other steps that could be taken in the interim to build up to a suspension?
As the court pleases, Your Justice, it's a possibility they must abide by the school rules. As the court pleases, Your Justice.
Agent, sorry, with your answer currently, now I am forced to ask. The pass rate for this particular school was very low, but with the new principal coming in and bringing these strict measures, the pass rate increased substantially. So are you saying that we should emphasize more on pass rates rather than bringing up students or learners who are empathetic? And so I think generally what I'm trying to drive at is, are you more concerned with people passing exams than building people who are strong in character? Do you understand my question?
As the court pleases, Your Justice, can you please simplify your question?
I am asking, as the school board and as a school, are you more concerned with bringing up learners who are having excellent grades than learners who are having excellent grades and who also are strong in character? So that's character and learning. What kind of students do you want to bring? Are you concentrating more on slavishly following rules so that at the end of the day people pass? Or would you want to have students who are strong both in character and learning? Do you understand my question?
Yes, Your Justice. As the court pleases, Your Justice, we want learners to be strong in character, and at the end of the year, we also want learners to pass well, because That is what they went for to school. As the court reasons, I would like to continue. Your Justice, to show the constitutionality of Section 4 of the School Code of Conduct, you also refer to the case of Head of Department of Education, Free State Province versus Harmony High School and another 2014 Constitutional Court, paragraph 58, where it was held that the court must be aimed at establishing disciplined and purposeful school environment dedicated to the improvement and maintenance of the quality of the learning process. Your Justice, we therefore submit that this ruling supports Section 4 of the School Code of Conduct and shows its constitutionality, as Section 4 aims to reform the school. Your Justice, to show that it is constitutional, we also refer to the case Anthony Governing Body, Settlers High School 2002 High Court, paragraph 17, where it was held that the question should be asked in this regard, whether or not prohibition is aimed at promoting positive discipline and whether or not non-compliance therewith justifies punishment or some other form of sanction. This requires a spirit of mutual respect, reconciliation, and tolerance. With your Justice, we also submit that the prohibition, which is Section 4 of the School Code of Conduct, is aimed at promoting positive discipline as it was implemented to maintain focus and discipline. As cell phone were a factor that disturbed.
Counsel,
Your Justice.
your time is up. I'll give you 30 seconds to round up your arguments, and then you should hand over to your co-counsel.
Your Justice, as the court pleases, counsel for respondent has shown this honorable court that Section 4 of the School Code of Conduct is constitutional and does not violate the learner's rights in terms of education and privacy. Counsel for respondent requests this honorable court to declare that the High Court was incorrect in finding Section 4 of the School Code of Conduct constitutional. As the court pleases, I will let you hand over to my co-counsel.
Thank you, first counsel on behalf of the respondent. Now we'll have the second counsel on behalf of the respondent. Please remember to advise the court how much time you'll be taking.
8 minutes.
All right, thank you. You may begin.
This is the court. I am Matiso Tladi, and I'll be focusing on the second issue as stated by my co-counsel. Your Justice, I'll be submitting to this honorable court that the SGB's decision is constitutional, as it has right to suspend learners guilty of misconduct. I'll be showing the court that the SGB's decision does not violate the learner's right in terms of Section 17 of the Constitution. Your Justice, counsel for the respondent therefore argues that in line with the Regulation of Gathering Act, Section 3 and Section 12, and the case Mulungwana and others versus and another 2019-1 SACR 429 Constitutional Court. We will show that the SGB's decision was constitutional. Your Justice, the SGB suspended the 6 learners because of recent events. As learners convened and picketed against the suspension of students for having cell phones and the use of corporal punishment at school. We argue that in terms of Regulation of Gathering Act, number 205 of 1993, Section 3. Section 3, subsection 1 says that the convener of a gathering shall give notice in writing signed by him of intended gathering in accordance with the provisions of section. We also refer to Section 12, subsection 1, which says that any person who A, convenes a gathering in respect of which no notice or adequate notice was given in accordance with the provisions of Section 3, or shall be guilty of an offense and on conviction liable. Your Justice, we argue that the learners did not provide notice for their assembly and therefore liable for conviction. This is also proved by the authorities informing the learners that this assembly is illegal and
should disperse, which is why the SGB was on legal grounds to take action against as a business of court.
Do you know the provisions for right to assembly? What is the maximum number, the minimum number for assemblies that do not require you getting a police clearance?
As a business of court, no. Yes.
Do you understand the question?
As a business of court, I would like to just please repeat the question.
So when you are expected to hold a protest, you are to get a permit from the authorities. But in an instance where there is a certain number, there is a minimum number that you can hold a protest without necessarily getting a permit. So do you know that number? Do you know how many people? And then relating it with the students, do you know what was the number of the students? And do they require a permit for the number of students that were particularly in this particular protest?
As it pleases the court, the number of the participants must be 60.
You can proceed. Sorry.
Which is why the SG, Your Justice, we submit that in terms of Section 17 of the Constitution, which says that everyone has the right peacefully and unarmed to assemble, to demonstrate, to picket, and to present petition. We submit that conveners of a gathering should ensure that their gathering does not result in a violent nature, and they are required by the Regulation of a Gathering Act to provide notice before the gathering. Justice, they failed to provide notice and were unable to fully control the gathering, since they closed down the school and a fire occurred a few hours after the gathering. Your Justice, we also refer to case Mlungwana and others versus another 2019 SACR 429 Constitutional Court Mlungwana case. Paragraph 16, it was held that if gathering proceeds without a formal notice, when Section 12 notice, then Section 12 subsection 1 provides that it is a criminal offense to convene a gathering without giving the requisite notice as prescribed in the Act. It is only a convener who is criminally liable for a failure to give notice of a gathering under Section 12, subsection 1A, which is why the SGB suspended the 6 conveners of the Assembly, which is the 6 suspended learners, and because they failed to abide by all regulations imposed on the right to assemble and gather. They were held liable and convicted in a form of suspension, which is why the SGB came to the decision to suspend the learners, which shows that the SGB's decision is constitutional. Your Justice, in summation of our arguments, Counsel for the Respondent has established that the Section 4 of the School Code of Conduct is constitutional and does not violate the learner's right to privacy and education. Counsel for the Respondent has also established that the SGB's decision is constitutional as the SGB is well within its right to suspend learners who are guilty of misconduct and does not violate the learner's right to peaceful assembly in terms of Section 17 of the Constitution, as this is subjected to the regulation of gathering. Counsel of the Respondent requests this court, 1, to declare that court was correct in finding constitutionality of Section 4 of the School Code of Conduct and finding that there was no violation on the right to education. 2, to declare that the High Court was correct in finding that the SGB's decision is constitutional and does not violate the learner's right to peaceful assembly in terms of Section 17 of the Constitution. I thank you.
Thank you, counsels, on behalf of the respondent. Thank you for your submissions. We will now give the floor back to counsel for the applicant for their rebuttal. So respondents, you may mute yourselves.
Your Justices, the applicants mentioned that the applicant's rights to basic education were limited in a just manner. Your Justices, in terms of Section 36, we must consider Section 1, subsection A, the nature of the right. In this case, your Justices, the nature of the right is a very important right, because your Justices, a right to basic education entitles you to a better future. Your Justices, secondly, the school could have applied less restrictive measures in terms of limiting the right to basic education, without having to have the learner suspended. These less restrictive measures, your Justices, include detention, a right out, without having to directly suspend the learners. Secondly, your Justices, the respondent argues that Section 4 of the School Code of Conduct was in line to establish with its purpose. Your Justices, even though it was in line with establishing its purpose for a disciplined school, in Pile's case, it was stated that both discipline and education are legitimate goals. However, care must be taken not to state the school's interest too broadly. Your Justices, in this case, we submit that the school stated its interest too broadly of a free cell phone area and did not consider the negative effects the suspension will have on the learners. Your Justices, in this case, the school could have punished the learners for contravening Section 4, but they could have done so in using less restrictive measures. These less restrictive measures, your Justices, include detention without having to suspend the learners. Secondly, your Justices, the applicants mentioned that the Schools Act allows for principals to serve without a warrant, but your Justices, in the Schools Act, conditions are stipulated. It is stipulated that it must be under the suspicion that there is a dangerous or illegal substance possessed by such learner. The Schools Act of Justices defined an illegal substance. It defined it as any unlawful, intoxicating, or stupefying substance. Your Justices, as the counsel for applicant, we submit that in this case, cell phones do not fit into that definition. It was unjust for the principal to search the learners without a warrant, as cell phones do not fit into that definition because cell phones are not intoxicating, nor are they stupefying.
Thank you. Your time is up. And I gave you a few seconds to conclude your sentence. Thank you. We have heard all submissions from both the applicant and the respondent. Congratulations, your first round is now behind you. So all those nerves and all those jitters have come and produced something. You should be proud of yourselves. That was excellent presentations and excellent arguments being made by people who haven't even started a degree in law. So that is very commendable. I believe that we can give you feedback, constructive feedback that doesn't pertain to the matters or the substantive matters of the case. So I will ask my learned sister and my learned brother if they have any feedback that they'd like to offer you, and then we can carry on from there. So maybe let me start with my learned sister, Justice Baum.
Guys, I'm really impressed. You have no idea. I'm here and I'm wondering, when I was in high school, I have no idea. I don't think I would be able to do this during my time in high school. So I just want to commend you first for showing up and for taking up this challenge. This is incredible. Your arguments were straight. Your question answering was amazing. You understand the facts of this case, and your commitment and the arguments that you are bringing forward. It just shows me that you are willing to be involved in a system that will really change things. And I'm really just proud of you all. And I wish you good luck as you proceed in the competition. And I know that I'll definitely be seeing you guys because you have really done so well. And I know that you would proceed to the next round of the competition because you are just incredible and amazing. And you should be very, very proud of yourselves.
Good afternoon again, all. A very well done to all the participants. You guys were clear, you guys were concise, and you were confident in addressing the court's questions. May you keep up the good work and the thoroughness as well. Attention to detail, which is very commendable and what is required in such competitions. So yes, very well done to all each of you. and all the best in progressing through the competition.
All right, thank you everyone. Even though we had some difficulties at the beginning, we still overcame them and we are here now. So we are running behind time, so I believe that it is time that we end this session. A reminder to the justices that we need to submit our score sheets within 10 minutes of the completion of this round. So between now and the beginning of the next round, if you're judging in it, please ensure that you've sent your score sheets to Als Joyce, UCC Philip, and UCC Simon. Thank you so much, everyone. The teams may leave the room.
I have a question, please. The score sheets, if I see it correctly, where is it? Just trying to find it. It has, do we use individual score sheets for each applicant respondent, or I don't know?
Let me just quickly answer that one. In total, you're sending 2 score sheets here. So one for applicant and one for respondent. Each score sheet will have space for both speakers.
Okay, no, that's fine. That's fine. Thank you.
Yeah, you can let in the other judges and get started with them whilst we're leaving. Thanks.
Afternoon. This is still Court A, and I'm also meant to stay for session 2 in Court A. So may I stay, or do I go and come back? Okay, sure. Greetings, Mr. Thomas.
Yeah, Pule J stays in the same courtroom because he is a judge for the next session as well.
Hi, everyone. Seems we have one team in here. Let me just quickly check if in accordance with the schedule, this is the team that's supposed to be in this court at this time. This is Court A, or is it B? What court is this, actually? Let me see.
I understand this to be Court A.
Court A. Thank you, Thomas. Court A, Court A. We are supposed to be running the second session. Yes, 206 respondent is here, but 202 applicant is not here yet, unless they are in the waiting room. No, they are not. We can commence the round as an ex parte round. Thank you very much. Team 206, you can basically make your arguments as an ex parte team. I will leave the court for the presiding judge to basically take over.
Simon, before you leave,
yes, Joyce.
Let's just confirm. Courtroom A is 202 and 206.
Yes.
So 202 is missing.
Yes, 202 is missing. I see there is a team supporter for team 109. Unfortunately, I'm going to have to kick you out of the courtroom because your team
supporter 109 must leave.
Around. So I'm
Okay.
removing team supporter. There.
Right. So we need to locate 202.
We can locate team 202, but in the interest of time, seeing that things are running a little bit late, I would just advise that we begin with the respondent, even if we try and locate them. I see JP Machilo is here, so I'm going to leave the session for her to basically take over the session, and they can hear an expert around in the meantime.
Simon?
Yes, Mema Level.
Hi, Simon. Have you realized that, did you see my email whereby one school from KZN has only been allocated one?
I have not seen it. I'll try to check my email as soon as possible. I am a bit
yeah, maybe you should attend to it because they've only been allocated once, and that maybe might have been just a mistake that needs to be attended to. You say that the team that is missing is 20 what?
202. I currently just put the team, the other team in the waiting room, so that we can have.
Let me try to check what team is that, and then let's try to communicate with the provincial coordinator responsible for that.
Okay, no problem. But I will just indicate we are running a little bit, very much late schedule. My fear is that judges effectively make themselves available for the particular times which we ask them to make themselves available. And effectively, this session is supposed to be off in 18 minutes. And so it would be in our advantage to actually commence with an ex parte, because that would mean we would finish within 20 minutes, and effectively we would still be able to get the judges within their schedule. And yeah, that's my biggest fear. The judges are only available for the times that we ask them to make themselves available, and not after or before. And so we are already running late. It would be wise instead to commence with the proceedings. So I will currently leave the session, and Dunga Mashilo, as JP, you can please commence the session in 2 minutes time, if at 25 minutes past, if the other team is not in the courtroom. I need to be going off to the next sessions to just check if they have already started or they need my permission to basically set them off. Thank you very much. Bye.
Okay, bye.
Thank you, everyone. As Simon has said, we will be starting in the next 2 minutes. Just before that, I want to check that the speakers' mics are working. So if you could just please say something so that we can confirm there's audio.
Hi, afternoon, ma'am.
Okay, perfect. Thank you.
Thank you. Ma'am?
Yes?
Do we should we turn on or off our camera?
No, please turn your camera on for your presentation.
Okay, thank you. Ma'am? Ma'am?
Yes?
Can we use our phones to set a timer?
Yeah, you can use your phones to set a time on your side, but I do have cue cards that I'll be showing you to show you how much time you have remaining.
Thank
I might
you.
just. Okay, with that said, court is now in session. This case concerns or rather this will be an ex parte pleading of the respondents, Team 206, representing Njondolo Combined School Governing Body. My name is JP Mashilo. Alongside me, we have your justices. Let me just get their names. Justice Thomas as well as Justice Bule. Please remember to indicate how much time you would like to reserve for rebuttal and how long your pleadings will be. And without further ado, the first speaker for respondent, you may get started, if this is okay with my fellow judges.
My sister Justice Mashilo, I see a message saying they're trying to connect to 202. So I don't know if that.
I think let's just give it another 2 minutes, but we did receive a direct order to begin at 25 past.
Okay.
Hello.
There we go. Is that team 202 the applicants? Okay, perfect. Given that we are running a little bit late, we're going to go straight into the session. Can we please just test your cameras, that the cameras are working? And the audio, if you could just say something, please.
Hi.
Okay, even a sigh will do. Thank you. Then just to officially begin again, court is now most officially in session. This case concerns the applicant, the 6 learners of Njondolo Combined School, as well as the respondent, the governing body of Njondolo High School. I was just saying, please remember to indicate what time you're reserving for rebuttal, as well as how long you're speaking for. If the justices agree, I think it's better if the speakers only turn their cameras on while they are speaking. And if your team is not speaking, just keep the camera off to reserve some bandwidth. And then I'll be showing you time cards throughout your rounds. Okay, without further ado,
Hello.
yes. Okay, I think that was just an accidental interruption, but applicant first speaker, you're up.
Good day, your justices. I am Lubanga Mlamne, and with me is my co-counsel Atandile Nyaga, and today we appear in behalf of the applicant. If it pleases the Court of Justices, may I provide a summary of the facts. And today I'll be taking 10 minutes of this court's time. My co-counsel will be taking 8 minutes of this court's time and reserve 2 minutes for rebuttals. And if it pleases the Court of Justices, would the court find the summary of the facts helpful?
Yes, please.
6 learners from Njondolo Combined School carried cell phones to school. Teachers found out about the cell phones and confiscated them. The matters were brought to the SGB and the SGB decided to suspend these 6 learners for the rest of the year. The learners saw the unfair decision that the SGB decided upon and decided to protest against the school, the respondent in this case. Honorable Justices, this concerns the protection of a young group of learners and the protection to their rights. Honorable Justices, this concerns the protection of a young group of learners and their rights to privacy, peaceful assembly, and their rights to basic education. Today, Your Justices, I'll be taking the first issue, which is whether or not Section 4 of the School Code of Conduct is unconstitutional and violates the learner's right to privacy and basic education in terms of Section 14 and 29 of the Constitution. My co-counsel will be taking the second issue, which is whether or not the SGB decision to suspend the learners is unconstitutional as it violates the learner's rights to peaceful assembly in terms of Section 17 of the Constitution. And if it pleases the Court of Justices, I would like to begin with argument 1, if it pleases the Court. This argument 1, to briefly summarize it, proves the unconstitutionality of Section 4 of the School Code of Conduct with regards to privacy, if it pleases the Court. We firstly submit that, Your Justices, Section 4 of the School Code of Conduct is unconstitutional as it reads. The use of cell phones, whether on or off by learners on school premises, is prohibited. Any learner found in possession of a cell phone shall have their phone confiscated and may be suspended. Your Justices, we as the counsel of the applicant submit that Section 4 of the School Code of Conduct is unconstitutional as it infringes on Section 14 of the Constitution, which states that everyone has the right to privacy, which includes not being searched and having your possessions seized. We see, Your Justices, that after one cell phone fell out of a learner's pockets, the rest of the teachers searched the learners, and that's where 6 other cell phones were found and confiscated them, which is unconstitutional, as Section 14 of the Constitution includes not being searched, and number 2, not having your possessions seized. And we see, Your Justices, that both the teachers and Section 4 of the School Code of Conduct in this case have breached those boundaries, whereas we see that the teachers physically searched the learners, and Section 4 clearly promotes the confiscating of the learner's cell phone if such a learner is to be found. So, Your Justices, we as the Council of
The School Code of Conduct is not just imposed on the students. They have to sign the Code of Conduct, which means that they're essentially signing to abide by it. What role does that play in your arguments?
As it pleases the Court of Justice, to answer your question, we submit a case where Bakazia versus Nadia case, where it was stated that consent to a contract can be declared invalid if the contract itself is unconstitutional. So, Your Justices, we as the counsel of the applicant submit that the consent of the learners to the Code of Conduct of the school must be declared unconstitutional, as Section 4 of the School Code of Conduct is unconstitutional as it violates the learner's right to privacy and education, if it pleases the Court.
Counsel, if I can ask, the way I read the clause, it says, if you're found in possession, the clause doesn't allow, or on its face of it necessarily allow searching or not searching. It just says if you're found in possession. So does that impact whether it's unconstitutional, or is it just that the implementation was unconstitutional and that the students were searched?
Your Justices, can you please repeat your question, Your Justice?
Sure. So the clause says, the use of cell phones shall at all times be prohibited. Any learner that is found in possession of a cell phone shall have that phone confiscated and may be suspended. Now, you're saying that the search of the students, the 6 students, was unconstitutional. But my question is that is not what the clause explicitly provides. Clause 4 doesn't explicitly say you can be searched. Are you saying that the clause itself is unconstitutional, or that just the search of the students was unconstitutional?
We submit, Your Justices, that since Section 4 of the School Code of Conduct is in itself unconstitutional, so that since the learners carried the cell phones to school, and Section 4 of the School Code of Conduct is unconstitutional, and since I've previously stated that consent to whether or not the consent of a contract must be declared invalid if the contract itself is unconstitutional. So if the code of conduct includes the possession, if the learner is found in possession of a cell phone, and we submit that the school should have searched with reasonable suspicion, should have searched the learners with reasonable suspicion, and we therefore submit Section 28A, subsection 2 of the South African Schools Act, which states that the principal or his delegation may randomly search a group of learners if any dangerous object or illegal substances are found. So we submit that, Your Justices, since a phone is not a dangerous object or it is an illegal substance, we submit that the school in this case shouldn't have searched the learners in this case, if it answers your question, Your Justice. Moving on, Your Justices, we as the counsel of the applicant have come about reasons to why privacy is so important to an individual. Privacy, Your Justices, is important to an individual, not only as it is essential to autonomy and the protection of human dignity, serving as the foundation upon which many other human rights. Number two, privacy helps us, Your Justices, to establish boundaries to limit who has access to our bodies, possessions, information, as well as our communications. And we submit that all these reasons to why privacy is important should apply to our applicants in today's case. And Your Justices, basically, Section 4 of the School Code of Conduct is unconstitutional because, number one, it doesn't abide with Section 14 of the Constitution. Number two, we gave reasons to why Section 4 of the School Code of Conduct is unconstitutional, and we gave reasons to why privacy is so important to an individual and why it should apply to our applicants in today's case. Moving on, to Justices, to the second issue, which is the unconstitutionality of Section 4 of the School Code of Conduct with regards to basic education, we therefore submit Section 29.
Sorry, Counsel, before you move on, regarding the right to privacy, the Constitution allows for limitations on certain rights according to Section 36. Does the limitation that has been placed on the right to privacy not meet the standard in Section 36?
We submit to Justices that the limitation does not justify the actions of the school. As I've stated, that for a school to search, there must be a reasonable suspicion that for that particular search, that particular day, Your Justices. And if it answers your question, we would like to submit Section 29 of the Constitution, which states that everyone has the right to basic education, including adult basic education. Everyone, Your Justices, including learners in this case, and if there's a certainty on suspension of the learners due to Section 4 of the School Code of Conduct, which clearly promotes the suspension of the learners, then Section 4 of the School Code of Conduct would be denying the applicants' rights to education as they are entitled to it. Your Justices, we further submit the MEC of KwaZulu-Natal versus Pillay case, paragraph 98, which states that discipline and education are both legitimate goals. However, care must be taken not to state the school's interest too broadly. We therefore believe, as the counsel of the applicant, Your Justices, that a school should provide both discipline and education as their legitimate goals, but we have to weigh the best interest of the child in this instance, and we therefore submit Section 28, subsection 2 of the Constitution, which states that a child's best interest of paramount importance in every matter concerning the child. And my Justices, in a school, the best interest of a child is of receiving education. And if the respondent in this case does not abide with that, then it should be deemed unconstitutional.
Counsel? Pardon me. A question. With regard to Section 4 and the right to, well, in contrast to the right to basic education, which would then, I would say, include the right to have a conducive environment to learning. And in light of the facts showing that the use or possession of cell phones is not conducive to a constructive learning environment, we could say, would you not say that Section 4 of the School's Code of Conduct is a reasonable and justifiable limitation to things like privacy, to the right to privacy? What's your take on that?
We submit your justice.
Sorry, and in fact promotes the right to basic education that that the learners have.
We submit your justices that less restrictive means could have been done by the respondent in this case, such as just confiscating the phone or just sending the learners to detention, not to take extreme measures as to suspending the learners in this case, your justices. And in conclusion of my argument to justices, I've proven that Section 4 of the School Code of Conduct is unconstitutional as it violates the learner's right to privacy and basic education. And with that said, I would like to give on to my co-counsel to continue with argument 2.
Thank you, Counsel. Speaker 2, whenever you're ready.
If it pleases the Court of Justices, I am Attorney Lemyaga, and I'll be taking 8 minutes of this court's time. If it pleases the Court of Justices, I'll be addressing the second issue, which is whether or not the School's Code of Conduct, the SGP's decision is unconstitutional as it violates the learner's rights to peaceful assembly in terms of Section 17 of the Constitution. If it pleases the Court of Justices, I'd like to move on to my first argument. We would like to submit Section 17 of the Constitution of South Africa, 1996, which states that the right peacefully, unarmed to assemble, to demonstrate, to protest, and present petition. This right, the right to peaceful assembly, shall at all times be recognized. No restrictions may be placed on the exercise of this right other than those imposed in conformity with the law and which are necessary in a democratic society. This law was drawn from the United Nations International Government on Civil and Political Rights. Your Justices, to support this law, we submit that the applicants were having a peaceful protest in a sense that they never vandalized any of the school properties, and they were holding a peaceful protest outside the school gates, which means that they had their rights to demonstrate and present all their grievances.
Counsel, does one not need to consider, you say it's peaceful, does one not need to consider the events leading up to these, that you had, that there was a building that was on fire, there were bins that were set on fire. Does that not impact the nature of this protest, considering it in its full context?
Your Justices, we believe that the protest was peaceful in the sense that when the police came and inspected the scene, no culprits were identified, which means that this doesn't verify that our clients were the one who started the fire at the school. If there are no further questions, Your Justices, I'd like to move on to my arguments. With reference to the South African 82 of the Constitutional Court of Gore's case, paragraph 61, which states that the right to freedom of assembly is central to our constitutional democracy. It exists primarily to give a voice to the powerless. Indeed, it is one of the principal means by which ordinary people can meaningfully contribute to the constitutional objective of advancing human rights and freedoms. Your Justices, coming from a history and background where freedom of expression and freedom to protest wasn't a freedom that people of color would enjoy freely. So nowadays, this leaves no phobia for people of color to protest against injustices as to how the applicants were doing in this case, Your Justices. So they had every right, Your Justices, because they were coming from that background of being deprived of the rights to peaceful assembly and to demonstrate their grievances. If it pleases the Court of Justices, I'd like to move on with my arguments. As the representatives for the applicants, we have, with reference to Section 36 of the Constitution, we believe that there shouldn't have been less restrictive means to achieve the purpose of the learners. There shouldn't have been quick decisions made by the SGP to suspend the learners just because the learners were protesting against the school. This doesn't put them on the wrong, Your Justices. We also believe that the school should search for cell phones when there is a reasonable and justifiable manner. And in this case, Your Justices, the school searched for learners when there was no reasonable suspicion. If it pleases the Court of Justices, I'd like to move on to my third argument. The rights of the learners to education and peacefully assemble should have been limited in a fair manner, and the individual who is subject to such authority is treated fairly and justly. The suspended learners in this case were not given a platform to voice out or even defend themselves. Fair procedures during disciplinary hearings serve the purpose of facilitating accurate and informed decision-making. It also ensures that decisions are made in the public interest and that important procedural values are followed. Your Justices, with accordance to the following rules, now form the Bill of Rights in accordance to the administrative action in Section 33 of the Bill of Rights, which states that, number one, the individual must be given an opportunity to be heard of the matter. Number two, the learner must be informed of considerations with count against him to defend him or herself properly. Number three, reasons must be given by the administrative for any of the decisions taken by the people in authority. And your Justices, in this case, the learners who were suspended, they were not given a platform to voice out or even defend themselves. The SGB made quick decisions to suspend the learners from the school grounds. And your Justices, we believe that this was unconstitutional according to the law. If it pleases the Court of
Oh, I see, to my Justice.
Thank you, my sister. Counsel, does the duration of the suspension matter? Because the way I understand it is that this is the maximum period of suspension. If they had only suspended them for a week or a month, would that have made it less? Would that have made it constitutional if it was for a shorter period?
If it pleases the Court of Justice, may you please repeat your question?
So the facts of the matter is that the students were suspended for the maximum period because of their protest. Does that change whether it was unconstitutional or not? If they had been suspended for a short period of time, would that mean that this was constitutional?
Your Justice, to answer your question, we believe that the suspension for the learners was very extensive. With that, we submit Section 9, subsection 1A of the Constitution, which states that the governing body of a school may, after fair hearing, suspend a learner as a correctional measure for a period not longer than a week. Your Justices, according to the facts, this gives us a clear interpretation that the learners were actually suspended for more than a week, and this, Your Justice, is unconstitutional. If it pleases the Court of Justices, I'd like to remind the Court of the importance and the aim of education. Education should be directed to the full development of human personality and to the strengthening of respect and other human rights. Your Justices, we believe that education is not only part of what's happening inside the classroom, but for outside the world as well. Education helps train learners to be exposed to have an exposure of the outside world and have the expectations that they would come across. If this right is guaranteed to your Justices, it has the ability to unlock the enjoyment of other human rights and ultimately empower individuals to contribute and participate meaningfully in a free society. If it pleases the Court,
do you have any case law to support your submissions?
if it pleases the Court of Justices, I don't have any case law to support this.
Thank you, Counsel. You may proceed.
Sorry, Counsel. Question. Would you not say on a balancing scale, so Lady Justice's scales, would you not say that the greater student body's right to education, which includes accessing the education facility, and in fact, the best interests of all the learners would be to be able to access the school and then to be taught in an environment conducive to learning? Now, considering that, yes, your clients do have a right to protest, would you not say that they could have done otherwise? And so the HGB was justified. The decision was reasonable and justifiable in light of the greater concerns regarding the best interests of all the learners, as well as, of course, the right to education, which was sought to be enforced by the SGB. So that being said, it was reasonable and justifiable for the SGB to do so. Would you not say so? Or what do you have to say in response to that?
If it pleases the Court of Justice,
Sorry,
may I
Counsel.
repeat your question?
And just before you answer that question, your time has elapsed, so the court will grant you, if it's okay with my fellow judges, 30 seconds to answer the question, and then please conclude and we'll hand over to the respondents.
Your Justice, may I please rephrase the question?
All right, the question simply is, was the SGB's decision not justifiable, or rather it was in fact reasonable and justifiable in light of the greater concerns for the student body? What's your response to that? Because the competing interests, the right to assembly and then the right to receive an education essentially, which has been hampered by the right to assembly.
Your Justices, we believe that the SGB's decision was unreasonable and unjustifiable in this case, Your Justices, as the learners were having a peaceful protest. And besides that, Your Justices, the learners had the platform to voice out their opinions and the injustices that they're facing in the school grounds. So with that protest, it actually helped in giving other learners the opportunity to be free and say what they are concerned, say their concerns. If there are no further questions or Justices, I'd like to make my conclusion. In conclusion, we as the counsel for the applicant have shown that the learners do not deserve to be deprived of education by being suspended from the school grounds, and it is submitted that the school governing body should be able to make rules and policies that are legal and constitutionally acceptable and respect the rule of law of the Constitution. If it pleases the Court of Justices, I'd like to make my prayers. We therefore pray for the following orders. 1, for the school's code of conduct to be deemed unconstitutional. 2, we also pray that the SGB's decision to suspend the learners is unconstitutional and the learners may be allowed to attend school. If it pleases the Court of Justices, I believe I have said it all.
Thank you, Counsel, and thank you to the applicant bench. We now call on the first speaker of respondent.
As the court pleases, I will be addressing the issue of how the school governing body's decision is not unconstitutional and how it does not violate the learner's right to peaceful assembly. I will be using 10 minutes of this course time, and so will my co-counsel. As well as my co-counsel, Ms. Yanela Nseke, will be submitting the issue of Section 4 of the Mjondolo School Code of Conduct and how it is not unconstitutional, nor does it violate the learner's right to privacy and basic education in terms of Sections 14 and 29 of the Constitution. It pleases the court. Section 17 of the Constitution says, everyone has a right to peaceful assembly. Has a right to peaceful assembly, demonstration, picket, and to present petition. However, it aligns with the Regulations Gathering Act that talks about the notice of gathering. That means that the convener of a gathering or demonstration shall give notice in writing signed by him or her of the gathering and give of the gathering intended in accordance with the provisions of this section. The applicant, Your Justice, did not give notice on any of the three protests that had happened. In addition to that, they violated, and they being the applicants also violated the Gatherings Act, being Chapter 1, Section 1, that says a note that speaks about the notice of gatherings, not the notice of giving the notice of gatherings not later than 7 days before the date on which the gathering is to be held. Give notice to the gathering to the responsible officers. In this case, the responsible officers being both the respondents and the officers. Your Justices, during the first protest, the police arrived and told the applicants to leave as their protesting was unconstitutional and that it was illegal as they do not give any notice of the gathering. The applicants left and then came back for another 2 days doing exactly what they were told not to do, hence them violating the law and not respecting what the law stands on or its grounds. The applicants or justices had their protest for 3 consecutive days, and not on any one of those 3 protests did they think of letting us or informing us the school law about any of the protests. Yes, your justices, we understand that the first protest happened spontaneously. However, we argue that the first protest was not as spontaneous and as unique as the other 2. And then with the 2 protests, the applicants did not give notice on any of them, and even though that the police came and informed them about the notice of gathering, no rights were violated, your justices, and that as the applicants themselves failed to give notice or to tell us or to inform us, the school, about the right that they wanted to exercise. Again, no rights have been violated. Article 21 of the
Council.
Yes, ma'am.
You make a distinction between spontaneous protests and planned protests. In terms of the law, what is the difference or the impact of differentiating between those 2 types of protests? Does it affect the notice that needs to be given, or what is the difference, legally speaking?
Legally speaking, there's a difference between a gathering and a demonstration. A gathering is of 15 people, less than 15 people, and whereas when it's less than 15 people, a gathering, a notice is not necessarily be given. However, with a demonstration, and if it's above 15 learners or 15 people, a notice has to be given 7 days before the gathering, or at least 48 hours before the gathering is to be held. If it pleases the court. The Article 21 of the United Nations International Covenant on Civil and Political Rights says the right of peaceful assembly shall be recognized. No restrictions may be placed on the exercise of this right other than those imposed in conformity with the law and which are necessary in a democratic society in the interest of national security, public safety, public order, the protection of public health. The applicants suggested do not follow a number of rules. One being not giving notice on the two protests that they had. Another, dragging the large bins into the streets and blocking the premises of the school. And 3, making it difficult for the other learners to enter the school premises during the 3rd protest. The applicants failed to attend to the responsibilities of their rights, your justice, and then they come and tell us that their rights have been violated. This, your justices, should show how inconsiderate the applicants were of the other learners' rights, being Section 24 of the Constitution, the right to a healthy and safe environment, and Section 29 of the Constitution, being the right to basic education. The applicants violated the other learners' rights based on the rights that have been mentioned. And not only did they violate the school learners' rights, they also violated the people around the school, or the people that work or move around the school, as when they dropped the large fence into the street, they made it hard for the neighbors of the school to pass through that street, thus disrupting the peace and safety of the neighborhood. The justices, before reaching a decision, before our clients reached the final decision, they have tried a number of times to come to a conclusion with the parents of the applicants. Our clients.
Counsel?
Yes, ma'am.
While I can appreciate your concerns regarding the notice and regarding the disruption that was caused, the applicants have really made it clear that the right to protest, especially for school students, is incredibly important, as it is one of the only mechanisms for them to voice their concerns, especially against such a big and strong body like an entire school or a governing body. So in what ways can we still protect those rights?
If we can protect the rights having responsibilities or following proper protocol to us to being able to exercise the right is a way that we can protect that right. When the applicant, when or a learner decides that they're going to exercise the right to protesting, they need to acknowledge that that right has responsibility and give notice to the people as big as the school and tell them that they will be protesting against injustices or something that they do not agree with. But they need to acknowledge that the same right that by having those responsibilities means that that right is being protected.
Thank you, Council.
Our client sent a message. Our client sent a message to the parents of the learners to say that if they felt that a mistake had been made, they should come forward and that um and that and that um that a decision must be made and brought forward. However, Eddie, one of the applicants, sent a message to his friend telling him to bring posters to the school to protest against this. And then when they did so, they took away an opportunity that could have prevented all of this, an opportunity that could have had their grievances heard, yet they blocked the premises, the school, and the meeting could not take place. Before the SGB's decision did in no way violate the learners' right to peaceful assembly, as our clients did try to meet them halfway because of their protesting. Our client's decision was in no way unconstitutional because before the decision was made or before the final decision was made, our clients did try to come to an understanding or to reach a conclusion with the parents of the applicant. And they did try to hear him out, and yet the applicants did not allow them to do so because they blocked the premises to the one meeting that could have prevented everything that is happening right now. Counsel for the respondents therefore pleads that the Honorable Court rules in favor of the SGP's decision as constitutional and that our clients did in no way violate the applicant's right to peaceful assembly in terms of Section 17 of the Constitution. Would you please support? Thank you.
Thank you, Council. Second speaker, when you're ready.
The court, I'd like to begin with my the applicant, the counsel for the applicant, tells us that the search ordered on the learners of the Njamgo Combined School is unconstitutional. We tell the court that that is not right. As section 8.
Council, sorry, I'm not sure if it's just me, but I'm really struggling to hear you.
I can confirm that on this side, and it's strange since your co-counsel was quite audible. So I think maybe if you swap seats here, that might work.
Ma'am, can you hear me now?
That sounds much better. Thank you, Justice Thomas.
Okay. If it pleases the court, I'd like to begin with my rebuttal. The counsel for the applicant tell us that the search ordered on the learners of the Mjondolo Combined School was unconstitutional. We tell the court that that is not right, as Section 8A, Article 3 of the South African Schools Act says that a school may conduct a random search if reasonable evidence of illegal activity taking place is given. And that is what the school had found, as a learner was found with a cell phone in possession earlier on that day. Moving on to my speech. We, counsel for the respondent, argue that Section 4 of the Mjondolo Combined Schools Code of Conduct is not unconstitutional. It does not violate the learner's rights to privacy in terms of Section 14 of the Constitution, and does not violate the learner's right to basic education in terms of Section 29 of the Constitution. Your Justices, Section 4 of the Njondolo Combined Schools Code of Conduct, which states that the use of cell phones, whether on or off, in school premises by learners shall at all times be prohibited. Any learner found in possession of a cell phone shall have that phone confiscated and may be suspended. In terms of the section being unconstitutional, we submit that it isn't, as Section 8, subsection 2 of the South African Schools Act states that the code of conduct referred to in subsection 1 of Section 8A must be aimed at establishing a disciplined and purposeful school environment dedicated to the improvement and the maintenance of the high quality of the learning process for the learners in that school. This is exactly why the principal of the Njondolo Combined School decided to implement this section of the Code of Conduct. It was implemented to stop the learners from being busy on social media instead of focusing to what the teacher is busy saying in class, as this was a big problem in the school. It was a problem that needed intervention. This, Your Justices, was only one of the implementations made, but the improvement of the school's pass rate from 53% to 70% was indeed an indication that these implementations were created in the best interest of the learners and following the laws in the South African Schools Act.
Counsel?
Yes, Your Justice.
In order to enforce the section in the School Code of Conduct, the school then invaded or rather violated the right to privacy of the student. Doesn't that then make the section unconstitutional?
Your Justice, we as the counsel for the respondent argue that the school did not violate the learner's right to privacy. The school simply limited the learner's right to privacy. It practiced Section 36 of the Constitution, if it pleases the court. Secondly, in terms of the learner's right to privacy being violated, we argue that the school was not violating the learner's right to privacy. It had simply practiced Section 36 of the Constitution, which talks on the limitation of rights. Your Justices, as we all know, the right to privacy is a limitable right. The school's limitation of the right to privacy for the learners is also in accordance with Section 8A, subsection 3, Article 3 of the South African Schools Act, which states that a school may conduct a random search if reasonable evidence of illegal activity taking place is given. The school earlier on that day had confiscated the phone of a learner who dropped it. The learner was not following school protocol. We, the school, then believed that this was evidence enough for the school to suspect the other learners might not also be following school protocol, thus making the search conducted by the school constitutional. Your Justices, it was very important that the school acted to this, as we needed the other learners knowing that breaking rules is wrong. We couldn't have the learners of the Njondolo Combined Schools going back to the comfortability of not focusing in class, but rather being busy on social media. As we know in the court, was a big problem in the school. This then goes to prove that this implementation of Section 4 was not done in wanting the best for this was done in wanting the best for the learners and not to violate any of the rights. Yes, Your Justice.
On that which you just mentioned, weren't there less restrictive means to achieve the same sort of goals that you have?
Your Justice, the less restrictive means would have been not allowing learners to use their cell phones in the class, allowing them to bring them to school but not use them in the class. But we as the counsel for the respondent believe that that could have been tricky, as it is not guaranteed that if a learner has their cell phone in their possession, they will not use it later on during the day. Justice. Thank you. Dear Justices, we also believe that it is unfair that now the learners appeal to this court and say that Section 4 of the Code of Conduct is unconstitutional. It is unfair that they only after being caught not following school protocol that they knew very well about, then they have claims to say that this section is unconstitutional. We believe that the applicants are only saying this because they are scared of facing the repercussions for breaking school law and having cell phones in their possession. We also believe that it is not right for them to appeal that this section is unconstitutional, as this section of the Code of Conduct was not just implemented. It was implemented after the teachers, the learners, and the SGB agreed with the need for greater need for discipline in the Njondolo Combined School. This section was implemented after a consultative process with all the above mentioned parties. Lastly, Your Justices, with the learners' claims to the right of education being violated, we argue that the learners' right to education was not violated, as the learners knew very well about the cell phone law implemented by the principal and the SCB. They knew about the repercussions of having to bring a phone to school. They are the ones who chose to ignore the rules that are given to them by the school.
Counsel, does that mean if they violate the rules that they lose the right? Because your client has suspended these students effectively indefinitely, so for the maximum period allowed. Is that not that they've gone too far? Have these students not lost? Has your client not allowed these students to now lose their right to education? Is there not something else that they could have done or suspended them for a shorter period of time? Would that not have been punishment enough?
Your Justice, the cell phone problem in the school is very unique. The cell phone caused a lot of lack of discipline in the school. It was necessary that we suspend these learners for the maximum period of time. We are not blocking their right to education, as the learners will be allowed to come back to school after they have spent their 10 days at home and learned their lesson of not bringing cell phones to school, if Your Justice pleases. Your Justices, let us keep in mind why Section 4 of the Code of Conduct was introduced in the first place. It was to stop the school teachers from having to endure the bad behavior of the learners not focusing in class. We recognize that the applicants seem to know all their rights, yet the very same applicants or justices seem to forget that to those rights they have responsibility. In this case, their responsibility to their right to education was to follow the rule and the procedures given to them at school. This then proves that the Section 4 of the Njondolo Combined Schools Code of Conduct is not unconstitutional, and it is indeed created in the best interest of the learners, and it is in correlation with the South African Schools Act. Counsel for the respondent prays to this honorable court to declare Section 4 of the Schools Code of Conduct as constitutional and not in violation to the learners' rights of privacy in terms of Section 14 of the Constitution and 29 of the Constitution, which is the right to education. Thank you.
Thank you so much, counsel or the bench or the respondent. At this point in time, we can give the applicant an opportunity to give their rebuttal.
As it pleases the Court of Justices, I have allocated myself 2 minutes for rebuttals. Starting off with Justices, the respondent in this case alleges that the applicant should have given notice for their protest, and we as the counsel of the applicant submit that the first incident was a demonstration and therefore doesn't require a notice, since it consisted of 6 people, which is a number less than 15, which makes it a demonstration, Your Justices. So moving on, Your Justices, counsel of the respondent declared that a cell phone was a school may on reasonable ground search a learner who is suspected to be carrying a dangerous object or an illegal substance, and we therefore submit your justices Section 1 of the Schools Act, which clearly defines a dangerous object or an illegal substance as any explosive material or device, any firearm or weapon. And it would be absurd, your justices, to say that a cell phone is a firearm or a gas weapon, an explosive device, your justices. So we as the counsel of the applicant submit that since a phone is not qualified as an illegal or dangerous substance, then it means that the respondent's argument in this case has fallen flat. And your justices, we submit that since and the respondent in this case said that they have not violated the learner's rights, yet limited them. And we submit to justice that this is not true, since under Section 36, a school may on reasonable grounds apply subsection 1, which is the law of general application, and we see on Section 4 of the School Code of Conduct, nothing says a learner should be searched, but rather promotes the confiscating of the cell phones, which further drives that Section 4 of the School Code of Conduct is in fact unconstitutional. And to drive this point, your justices, we submit Antonio versus Governing Body of Settlers High School case, paragraph 17, which states that the question to be asked in this regard is whether or not non-compliance therewith justifies non-compliance or whether or not non-compliance therewith justifies punishment or some form of sanction, and this requires a spirit of mutual respect, reconciliation, and tolerance. And we see, your justices, we submit that the prohibition of learners from school premises was not aimed at promoting positive discipline, as there were no means of mutual respect, reconciliation, or tolerance done towards the students, since they were suspended from school with immediate effect, let alone without a fair hearing, your justices. And with that being said, your justices, we as the counsel of the applicant concludes that Section 4 of the School Code of Conduct must be deemed unconstitutional, and that learners' right to peaceful assembly must be acknowledged in this case. And with that being said, your justices, I'd like to take my leave.
Thank you, counsel. The respondents, if you have prepared Sir rebuttal, you will also be given an opportunity to go.
No, ma'am, we are good, thank you.
All right, thank you then. That is the end of the session. While we will not be announcing the winners or anything of this round, we will be deliberating and then providing you with a little bit of feedback afterwards. May I ask the host of this meeting to either please provide the justices with admin rights, or to please take the speakers to the waiting room just to allow the judges a moment to deliberate. And while that's happening, could the teams please write their names in the chat box and what speaker you were. So applicant 1, name and surname. Okay, we'll do that when they come back, I guess. We'll do the admin after deliberation. Thank you so much. Okay, Thanks, everyone. I think everyone in this room is safe to hear this information, but I just wanted to find out how the justices were feeling about the rounds, what sort of feedback we can give to them. I have been informed by Simon that we are judging individually with the score sheets we received via email, and that we don't actually tell them who won or who lost, just general feedback.
Yeah, I found them all to be quite knowledgeable of the facts, I must say, and I think they'd all looked at some of the different sections, not just the sections that they had been given. Yeah, I don't know if we want to sort of talk on individual speakers.
I think we can definitely do that, but in order to keep it brief, since there are quite a few of us here, maybe we'll give more specific individual feedback as a justice in the rounds when they come back. But in terms of the overall feedback, I think I definitely agree with the intimacy with the facts. I do think, though, that I wish they had a little bit of case law to support their arguments, and also that they relied on applying the facts to the law, because there were lots of instances where they were mentioning all these different sections but weren't necessarily showing us how they are applicable. But outside of that, I thought it was a relatively good round.
Yes, I agree. And the responses to the questions as well was very well and quite clear and concise, and it wasn't all over the place. So that was very good as well.
I definitely agree with that as well. I forgot to mention that the one thing they didn't do quite well was time management. There were people starting their arguments with 30 seconds to go. So I'll just flag that in the general feedback. And then does anyone else have any other comments before we let them back in?
Just maybe not a comment, but just a question. In terms of scoring, do we each individually score them on these score sheets, or do we give one as a panel?
So we do give scores individually in the score sheet template that was emailed, and then I think it also has details of who to send it to directly. So as soon as we get the names, we can all get started with that. And then if it's okay with you guys for the feedback, I think in considering everything that you guys just said now, I will give an overview and then hand over to the different justices if they want to say something that's more specific or give feedback to speakers specifically for their own improvement and for the next round and for some sort of satisfaction since they're not getting results in this round. So that was a question. Is that all right with everyone, or does anyone have any alternative?
Sure, that's
Okay, thank you so much. If the webcast support could please allow the teams back in. Hi, everyone. Welcome back to the rounds. First of all, let me actually turn my camera on so this is a bit more personal. But First of all, thank you so much for that round. We thought that the round was good and that you guys were well prepared for that round. So the way that feedback is going to work is, as I have explained, we will not be announcing who won or any of that sort of information. Instead, what we will be doing is giving you a few points of oral feedback for your own progress and development. And then also I'll hand over to the judges after that to give more individual or specific feedback. So while I'm doing that, please remember to put your name and surname in the chat box so that we can have that admin sorted out. So yeah, we'll start with the positives. The first is that you guys are impressively knowledgeable of your facts and can refer to them quite instantaneously. So it's very good to have an intimate relationship with your facts. It shows that you understand what you're speaking on, and that's something that was prevalent all around. So well done on that. Secondly, we think that you guys answer questions well, in that you include authority in the answers, but also that you give clear and concise answers, and that's a very impactful form of persuasion. Thirdly, just generally, there was a lot of reference to different sections, even ones that weren't included in your resource pack. So your knowledge of legislation and the applicable law is also quite impressive, and well done with that. That's an incredibly important part of mooting. So you can give yourself a pat on the back for that. And then just a few pointers on things that you could work on. The first is time management. So there were quite a few speakers beginning their second argument quite late in their presentation, or even after the time's up card is up, then continuing to go on. And a trick of how to navigate that is just to make sure that before your moot presentation, you allocate time to each argument. So for example, you must know that by 4 minutes into the presentation, I must move on to my second argument and wrap up the first one. Otherwise, I will not have time to complete that argument. The second thing you can do is use summaries and prepare summaries beforehand for your arguments that you aren't able to ventilate thoroughly, so that we do get a punch of the most important things that you want us to hear from that argument. And then the final thing you can do is just have a sense of awareness with time. So say things like, justices, I see my time is elapsing. Let me swiftly move to my next argument. So that's the time management. The second thing is, if you could please consider importing some case law into your arguments so that it has a stronger hold and applicability, and so that we can get a sense of the fact that the pieces of legislation you're arguing have been through court, and the court has had a certain stance that aligns with your argument. And then the last piece of advice moving forward is, while I had mentioned that you know your law really well, be sure to apply that law thoroughly. So go the extra mile and show us how the many, many different sections that you have named apply to the facts, and sort of how they relate to the core issues and the facts. So that was general feedback from across the board, input from each of the justices. And at this point, I'll hand over to any justice who wants to give more specific feedback. But I do want to say that you guys are very impressive, and well done on all the preparation that you have prepared.
So, thank you, Mr. Justice. Just to sort of emphasize that what's always useful is you get judges who like asking questions, and that can derail you when you're trying to, you sit and you've got a nice argument and starts point 1, point 2, point 3, and you can read that in 10 minutes and it will be perfect. But then the problem is that you encounter judges who like to ask you questions, and then you go on another track, or you end on a different point or something like that. So when you're preparing your arguments, don't sort of try and write out a 10-minute speech. Rather have a few key points that you want to hit, and hit the best point first, and then the next one second and third and fourth, and carry on. so that if you get a question that eats up your time, so that you run out of time, you spend all the time only arguing on point one, that's fine because that's your best point, right? So try and sort of just think of that structure for yourself, so that if you are derailed by questions, that it doesn't mean that your best argument is left in your written speech. Yeah.
Afternoon, all. Very well done again. I'd advise that in feedback, you continue confidently in raising your points and also listen to your co-counsel and the other arguments made by the applicants if you're the respondent, and try to also speak to those points that they're raising and counter those if you're on the respondent side. And obviously if you're on the applicant side, it's a bit more difficult to do that, but do listen to your co-counsel and try to link their arguments into your arguments, which will further bolster your argumentation overall, and it will improve your argumentation and delivery of your presentation. But otherwise, very well done. You're all confident and comfortable with the facts and the law, and you applied each of those with confidence. So that's impressive to note.
And I think to that point is that if a judge is asked a question of the other side, it means that that judge is probably struggling with that point. So try and sort of, if you are then the respondent, if they've asked the applicant a question on that, know that that's probably a point that you should go to with that judge. And on the other side, then the applicant, if they've asked that and the respondent, then in your rebuttal time, try and go to that point, because that's obviously a point that the judge is struggling with and trying to grapple with. And so that's a good place to say to the judge, I've heard your question, heard you ask the other side, they answered it like this. This is why they are wrong, and this is why my argument should be preferred.
Thank you so much, Justices. I just want to confirm that there aren't any other forms of feedback before we release the speakers. It seems then that that was everything. Thank you so much for everyone, to everyone for coming today. The names of the speakers are all in the chat box for my fellow judges. And yeah, that's it. Speakers, you may leave the meeting. Thank you so much.
Thank you.
Unless anyone needs the names or anything else, then I think it's also safe for the rest of the judges to leave the meetings. Yeah, that was it. Have a great day, everyone.
Thank you.
Thank you all.
Bye. Good thanks, Sumi.
No problem. Thanks.
Thank you.
Hi, everyone. I am just going to be going around all the other courtrooms, checking if we have judges in the other courtrooms who need to be here for a brief briefing. So yeah, I'll be back to brief you all just in a few minutes.
combined school and their decision to challenge the SGB in the High Court, arguing their suspensions were unconstitutional as they were merely exercising their right of peaceful assembly. I'll be presenting the first issue in this matter regarding Section 4 of the School Code of Conduct being unconstitutional and the violation of the applicant's right to basic education and privacy in terms of Section 14 and 29 of the Constitution. My co-counsel will be representing the second issue regarding the SGB's decision being unconstitutional and the violation of the applicant's right to peaceful assembly in terms of Section 17 of the Constitution. I would like to begin with issue 1, if it pleases the court. As the applicant, we put forward that a code of conduct must be aimed at establishing a disciplined and purposeful school environment dedicated to the improvement and maintenance of the quality of the learning process, as stated in Section 8, subsection 2 of the South African School Act, number 84 of 1996. And as said in State versus Harmony High School and another, both discipline and education are legitimate goals. However, care must be taken not to state the school's interest too broadly, as the child's best interest is also of paramount importance under Clause 28, subsection 2 of the Constitution. As the applicants, we contest that Section 4 of the School Code of Conduct is unconstitutional because, firstly, the processes of adopting a code of conduct were not followed by the South African School Act number 84 of 1996, provided in Section 8, subsection 1 states, subject to any applicable provincial law, a governing body of a public school must adopt a code of conduct for the learners after consultation of the learners, parents, and educators of the school. And goes on further to say, when a code of conduct is reviewed annually or when amendments are made, the above stakeholders must be consulted first. We submit that the above mentioned processes were not followed, as it is not clear in the facts of the case whether the learners and or parents were involved in the amendment of the new code of conduct. As stated in the facts that the new school code of conduct was adopted and implemented with immediate effect. This constitutes a limitation of the learner's rights and renders the school code of conduct unconstitutional under Section 8, subsection 1 of the South African School Act. We submit that the school is not justified in the expectation that the learners are obligated to comply with that code of conduct, as stated in the facts of the case that there is much resistance against the new measures. Secondly, we put forward that Section 4 of the School Code of Conduct is not in compliance with the Constitution, as it unjustifiably limits the rights to privacy and basic education, Section 14 and 29 of the Constitution, that this court ought to hold in the highest regard. And in accordance with Section 2 of the Constitution, all contract law and all law must be based with the accordance of the Bill of Rights. And we submit that once a public school has joined, you do not opt out of the system, and you're still obligated to follow the same constitution. The Code of Conduct asserts that
if found in possession of a cell phone, that cell phone will be confiscated. This directly violates the right to privacy in Section 14, subsection C of the Constitution, which states their possession seized. And Ms. Koza also orders a bag search of the learners, and 6 phones are found. This again violates the right to privacy in Section 14, subsection B, stating their property searched. We submit that this is an unjustifiable infringement of the learner's right to privacy because there were no reasonable suspicions for the principal to order a bag search. This is an unlawful act of the school. We submit that the school code of conduct violated the learner's right to basic education in Section 29 of the Constitution, because suspension in the first place for having something as simple as a cell phone can be seen as harsh, restrictive, or even excessive. In many cases, cell phones may be used for educational purpose if managed and controlled properly by either the school or the SGB themselves. Technologically, we've evolved so much to the point where we use cell phones in all aspects of life. Therefore, the punishment does not suit the harmless action. For all the above mentioned reasons, applicant respectfully requests that this court find that Section 4 of the School Code of Conduct is unconstitutional and that the applicant's right to privacy and basic education in terms of Section 14 and 29 was violated. As it pleases the court, we would like to move on to the second issue.
Honorable Justices, and may I please the court. I'll be dealing with the second issue in this matter, which is the SGP's decision is unconstitutional as it violates the learner's right to peaceful assembly in terms of Section 17 of the Constitution. If it pleases the court, I would like now to start with my submissions. My Justices, I have 2 submissions to make in continuation with the applicant's appeal against the respondents in this instant case. This deals with the decision of the school governing body to suspend the 6 arrested learners is unconstitutional. We will show that decision is ought to be overridden by the provisions made by the applicants within the Constitutional Bill of Rights. And the violation of the learner's right to peaceful assembly are not justified by the respondent under Section 17 of the Constitution. Firstly, I'll be stating the importance of the right in Section 17 of the Constitution of the Republic of South Africa. Secondly, I'll be addressing how the arrest and suspension of the 6 learners violates the learner's right to peaceful assembly. Section 17 of the Constitution states that everyone has the right peacefully and unarmed to assemble, to demonstrate, to picket, and to present petition. Section 17 of the Constitution guarantees that everyone who is unarmed has the right to go out and assemble with others, to demonstrate, to picket, and to present petition to others for any lawful purpose. Its meaning is clear and unambiguous. Anything that would prevent an unarmed person from assembling peacefully as limit the right in Section 17 that this court would hold in the highest regard, because it is the basis of our democracy, especially for children who cannot vote. This right is a vital tool for their political participation. Secondly, my Justices, we submit that the arrest of the 6 learners is unconstitutional for 2 reasons. First, there was clearly no reason to arrest the learners. We submit that the arrest is illegal and unconstitutional because they have not violated any right in the South African legislation. And the manner in which the police obtained the evidence was unconstitutional and should render this trial unfair. The 6 learners are arrested because of exercising their right of assembly enshrined in the Constitution of the Republic of South Africa. The police assert that it is an illegal gathering because notice has not been given. We submit that this court has recognized in the case of one and other versus the state and another, that Section 12, subsection 1A of the Regulation of Gathering Act of 1993 is constitutionally invalid, to the extent that it made failure to give notice or giving of inadequate notice by any person when convening a gathering a criminal offense, as this clearly constitutes a limitation of Section 17, and in this case, the gathering took place spontaneously, as stated by Precious in the fact that they just walked out of the school and formed a group spontaneously. And Section 12, subsection 2 of the Regulation of Gathering Act 205 of 1993 gives provisions if a gathering plays spontaneous. And we also submit that taking to the street to vent their frustration was the only viable venue they had to express their views and aspirations, as they were shut down by the school. We also submit that the arrest was illegal and unconstitutional because no riot damages to any property as a result of the assembly, as no evidence points that out, that violence was used. The police have no proof that the learners were armed, therefore arresting the learners would be infringing the learners' right to assemble freely. The arrest of Precious, Tadu, and Apiwe as the leaders of the assembly is unconstitutional because Section 11, subsection 2, paragraph B of the Regulation of Gathering Act states that it shall be a defense to a claim against a person or organization contemplated in subsection 1 if a person or organization A, that he or she did not permit or convene the act of omission which caused the damage in question, and B, that the act or omission in question did not fall within the scope of the objective, the gathering or demonstration in question, and was not reasonably foreseeable. We submit that it did not permit any act which caused damage, and if damage was made, it did not foresee it. Furthermore, we submit that the arrest of Eddie, Crystal, and Bali, because his WhatsApp messages were read by the police, is unconstitutional because it is in direct infringement of Section 4, which is privacy. The privacy of their communication infringed under clause 14 and under clause 35 of the Constitution, subsection 5. Evidence obtained in a manner that violates any right in the Bill of Rights must be excluded if the admission of that evidence would render the trial unfair. There were no reasonable suspicions for the police to look through his phone without his consent. We submit that the school decision to suspend the 6 learners is unconstitutional because it arises from the violation of the learners' right to peaceful assembly. We, as the applicant, argue that the 6 learners are suspended because...
I have a question. Can you address us again on the issue of suspension? Because if I am aware, Section 4 clearly states that the punishment for having a cell phone is suspension. Are you trying to tell us that that provision of the law is wrong, and if the provision of the law is incorrect, measures that the performance of such a school was very low? So how would you, yes.
My Justice, to answer your question, we as the applicant states that for the school to suspend the learners, since the school code of conduct states that if you bring a cell phone at school, you will be suspended. We say that that code of conduct is unconstitutional in itself, and furthermore, we put in this honorable court that to suspend a learner for bringing a cell phone at school is a harsh punishment. It's a cruel punishment, and it is not proportionate to the offense of bringing a cell phone at school. If I answered my Justice's question.
Yes, it did. You can proceed.
Thank you, my Justice. Because the applicant argued that the 6 learners are suspended because of an illegal act by police to arrest them. because of exercising their right of peaceful assembly. This suspension constitutes a limitation of the right in Section 17 of the Constitution because of the possibility of a suspension sanction, and a criminal sanction prevents, discourages, and deters and inhibits the freedom of assembly. This constitutes a limitation of the right to assemble freely, peacefully, and unarmed. And the Constitution guarantees that everyone who is unarmed has the right to go out and assemble with others to demonstrate, picket, and present petition to others for any lawful purpose. And anything that limits this right is unconstitutional, not with accordance with the Constitution of the Republic of South Africa. And therefore, the school is not justified in suspending the sixth. In submutation of our arguments, my justices, counsel for the applicants has established that legislation set in place to govern the school is illegal, and the decision of the SGB to suspend the sixth learners is unconstitutional and unjustifiable. Counsel for the applicants has shown that the applicant above mentioned rights have been violated by the respondent. Counsel of the applicant hereby asks the Honorable Court to grant applicant with the right to return to school and to change Section 4 of the School Code of Conduct for a lesser restriction that will not violate the learner's right and also keep a discipline at school. Counsel for the applicant respectfully requests this Honorable Court to declare that the High Court was incorrect in finding that there was no violation of the right to freedom of assembly, since the applicant right in Section 17 was clearly violated by the SGP in terms of suspending the system. As it is the court, will I be of any more indulgences, my justices?
I'm not sure if any of the other justices have any questions before we proceed to hearing the respondents' arguments.
Questions on my end.
Okay, perfect. Thank you very much. We'll now hear the counsel for the respondents. Thanks.
As it pleases the court, my justices. Thank you.
My Honorable Justices, spokesperson of the Deputy Minister of Basic Education, the Commissioner of the South African Human Rights Commission, Program Director, and the court at its largest capacity. I greet you all equally. I am Nsmcc, together with my co-counsel, Migdeli Madope, grade 11 learners from Mathemani High School, situated in Bushbuckridge, Mpumalanga. Honorable Justices, me and my co-counsel will be appearing on behalf of the respondents. Honorable Justices, I have a case to submit in terms of Section 4 of the School Code of Conduct, which is not unconstitutional and does not violate the learner's right to basic education and privacy, according to Section 14 and 29 of the Constitution. Honorable Justices, the SGB's decision is not unconstitutional and does not violate the learner's right to peaceful assembly in terms of Section 17 of the Constitution. Honorable Justices, let me take you a bit through the story. Njondolo Combined School is a school that was out of order the previous years before Ms. Kosa came into board as a new principal. But all came to a stop ever since Ms. Kosa was appointed as a new principal. The 6 learners were warned not to come with their cell phones to school, but they insisted they came with it. And with that, they were suspended. Honorable Justices, the 6 learners were suspended as the Section 4 of the School Code of Conduct states that the use of cell phones, whether on or off, by a learner on school premises shall at all times be prohibited. Any learner found in possession with a cell phone shall have that phone confiscated and may be suspended. Thereafter, the 6 learners went on an unpeaceful protest where they ended up
being arrested. Honorable Justices, the SGB was surprised to see their learners turn into monsters. Ms. Kosa then understood that they are learners. They can do anything without thinking it appropriately. But instead, it was wrong for the learners to raise their voice on an impolite manner. The SGB had a meeting. They decided to suspend the learners. Honorable Justices, as the Mjondolo Combined School, we stand firmly that Section 4 of the School Code of Conduct is not unconstitutional and does not violate the learner's right to privacy and basic education in terms of Section 14 and 29 of the Constitution. Honorable Justices, you can side with me here that the use of cell phones in class can always be disturbing. So it was our priority to take the cell phones from the learners. Honorable Justices, imagine yourself as parents. How would you feel if you send a child to school, that particular child of yours arrives at school, and some learners distract a class using their cell phones? How would you feel as a parent that your learner is not getting his or her right to basic education? Honorable Justices, I further submit that the School Code of Conduct was never violated in terms of Section 4 of the School Code of Conduct. We had to make sure that we abide by our law that we made on the School Code of Conduct. Honorable Justices, with all mentioned, we made sure that we take the cell phones from the learners, as well as suspending them. Honorable Justices, Section 36, subsection 1, limitation of rights, supports us why we had to search for the cell phones. We further submit that Section 4 of the School Code of Conduct is not unconstitutional in terms of Section 29 of the Constitution. The right to basic education was not violated at Mjondolo Combined School. Honorable Justices, let's look back to the school performances the previous years. It was low as 53%. But ever since the school honor.
You said the right to education was not violated, but the facts of the case say that the students were suspended. Are you telling us that the right to education of the students who were suspended was not violated?
Your Honor, to that question, in terms of the School Code of Conduct, a learner must abide by the School of Conduct because he or she knows that if you misbehave or act unlawfully to the School Code of Conduct, you may be suspended. So the 6 learners knew clearly that they will be suspended if they acted unirrational. May I proceed, Your Honor?
Yes, you may.
I was saying, let's look back to the school performance on the previous years. It was as low as 53%. But ever since the School Code of Conduct was implemented at the school, the improvement was there. The school percentage increased to 73%, to 72%, Your Honor. Honorable Justices, please count your numbers. I mean from 53% to 72%. That's a good achievement to the school. This makes it clear to the court that Section 4 of the School Code of Conduct made fruitful results to the school. My honorable justices, today, as the Mjondolo Combined School, we are able to send learners to universities. Honorable justices, do you know why? Here's the answer. Because today we produce bachelors that will be able to send our learners to universities. Honorable justices, This shows to the court that our Section 4 is constitutional. Honorable Justices, Section 29 was successfully practiced at Njondolo Combined School. Honorable Justices, we further submit that the SGB's decision is not unconstitutional and does not violate the learner's right to basic education in terms of Section 17 of the Constitution. Honorable Justices, imagine the destruction and havoc that can be there when learners are on an unpeaceful strike. They just do anything they want to do without thinking of the consequences. Honorable Justices, our right to movement was frightened as they were blocking roads, burning schools. Our right to life was frightened, so the learners' actions were unconstitutional. Honorable Justices, with all presented, the regulations of gatherings Act number 205 of 1993 was neglected as learners never bothered to give notice to the school or the police. They just engaged themselves on an unpeaceful picket or protest. Honorable Justices, when ruling on this, may you please look at Section 12 of the Gatherings Act. As the Njondolo Combined School, we are looking forward on producing fruitful results so that we can move forward swiftly as the school. My honorable justices, I will hand it over to my co-counsel, Ms. Jenny Majope. I thank you.
Greetings to my judges, my fellow contestants, and the court at its largest capacity. Appearing before you is Magdalene Majope from Mafemani Numalo Secondary School, and I will be submitting my argument as the respondent. Honorable Justices, Njondolo Combined School was an institution which was out of order and there was no discipline. The pass rate was very low, and it was difficult to teach while learners were busy with their cell phones. This came to stop when the new principal, Mrs. Koza, was appointed as the new principal. Honorable Justices, believe me, change happened at Njondolo Combined School. As the Njondolo Combined School, we stand firmly that the Section 4 of the School Code of Conduct is not unconstitutional. That the Section 4 of the School Code of Conduct is not unconstitutional and it does not violate the learner's right to privacy and education in terms of Section 14 and 29 of the Constitution. The School Code of Conduct went under a consultative process, meaning that we followed the Constitution. This makes it clear to us and the court at its largest capacity that we adhere and abide by the South African Constitution. Honorable Justices, we further submit that in terms of Section 14 of the Constitution, the school management did not violate the learner's right to privacy, as learners were warned the day before that the following day there will be searching of cell phones. Even the Section 36, subpoint D to E, supports us for the reason of searching their school bags. The School Code of Conduct, it is clear that the use of cell phone is not promoted in the Njondolo Combined School. In this manner, law must be applied equally to all the citizens of the country, including those learners. The learners have rights, and their rights have limitations, including their right to privacy. This shows us that the School Code of Conduct does not violate the learner's right to privacy under Section 14 of the Constitution. Honorable Justices, we submit that we did not violate the learner's right to education under Section 29 of the Constitution, since when the School Code of Conduct was implemented, the pass rate increased from 53% to 72%. This makes it clear to us and the court that the implementation of the School Code of Conduct is important. The learners deserve punishment. Since we wouldn't use corporal punishment, since it is not allowed in each and every school, we saw suspension as the right thing or the only choice to make. Learners are minors. They also need guidance from us as the management. As the counsel of the respondent.
Agent.
Your Honor.
You say learners are minors. Are you telling us that as a minor, your rights are not are to be upheld through an elderly person? Is that what you're trying to tell us? Let me rephrase the question so you understand better. As a minor, do you believe minors have rights? And if you do not believe they have rights, do you think that the rights of minors are tied to that of an adult?
Your Honor, the learners have rights, but their rights have limitations. So if they do not abide to the rules or laws presented to them, they must be penalized. I thank you. May I proceed?
You may proceed.
As the counsel of the respondent, we submit that the SGP's decision was not unconstitutional and did not violate the learner's right under Section 17 of the Constitution. Because since the learners did not give us the opportunity to respond to this situation, they just made an unpeaceful picket. They invaded the freedom of privacy for the road users, since when they were blocking the road and they vandalized the school belongings. Honorable Justices, they have violated the right to education. Your Honor.
Agent, you said the students vandalized the school property, but the facts are telling us that there was no culprit apprehended in that situation. Is that correct?
Your Honor, can you please rephrase that question?
You're saying that the students vandalized school properties, but the hypothetical facts do not state who. They state that there were no culprits apprehended for any destruction to the property. So are you telling us that you are just imagining without investigating properly who was the culprits behind that and just assuming that the students who were suspended are the culprits behind this incident?
Your Honor, the answer to this question is that for the fact that learners used the school bins to start fire, it shows us that they were unconstitutional and irrational. They used the school bins to start fire. The school bins are their school belongings.
I understand. Thank you very much. Thank you for that clarity. You may proceed.
The learners, they invaded the freedom of a movement for the road users, and they were blocking the roads by using their school bins, as I stated before. They even violated the right to education for the other innocent learners, who were not part of this situation. Presiding judges, let's look at paragraph 16 of Mlungwana's case. The learners did not give us a notice that they just made a strike. This made it clear to the learners to the court that the learners were irrational and unconstitutional. Honorable Justices, the learners violated the Regulation Act 205, number 205 of 1993, Section 3. As they made an offense, I plead the presiding judges to rule looking at the Section 12 of the Governance Act. Honorable Justices, let's look at the South African Act number 288, Section C. This shows us how lawful it is to have a school code of conduct in each and every school. I would like the court to rule on our favor and declare and acknowledge that the learners were wrong to protest without presenting their petitions first. To declare that the learners must apologize in writing and promise to adhere and abide to every law that is presented to them in the school premises. To declare that the school code of conduct is not unconstitutional and it does not violate the learner's right to privacy and education in terms of Section 14 and 29 of the Constitution. And that the SGB's decision is not unconstitutional and does not violate the learner's rights under Section 17 of the Constitution. I would like to thank the honorable judges as well as the court at its largest capacity for giving us this opportunity to present our argument. Thank you.
Thank you very much. I just want to confirm if any of the other justices have any further questions before we proceed to the counsel for the applicants, if they would like to address us on the rebuttal. And just to bear in mind that you each have 2 minutes. Well, the counsel for the applicants have 2 minutes to rebut.
Justice, I have one question, and that is, what is the respondent's understanding of consultation? Thank you.
Your Honor, can you rephrase your question?
So you mentioned that there was consultation on the drafting of the code of conduct because you consulted the Constitution. So I just wanted to make sure, is that your understanding of what the word consultation means? Thanks.
May I answer on behalf of my co-counsel? Honorable Justices, according to our case, when we look at it properly, it says that before the code of conduct was implemented at the school, it went under a consultative process, which means that learners, parents, and the school governing body were aware of the constitution, of the code of conduct. This shows that the learners knew the code of conduct because when they are enrolled on the school premises, they have to sign the school code of conduct. I thank you.
Okay, thank you. If we can please proceed to the applicants on their rebuttal.
Thank you, my justices. As it pleases the court, I would like now to point out the following errors that the respondent made in their past arguments. My lords, as we all know that the Constitution is the supreme law of the land. Under Chapter 1, subsection 2, it states this Constitution is the supreme law of the land. Law or conduct inconsistent with it is invalid, and obligations imposed by it. We submit as the counsel for the applicant that the code of conduct of the school is inconsistent with the Constitution of the Republic of South Africa because it violates the learner's right, unjustifiably in that violates the learner's right under subsection 14 and 29 of the Constitution. Furthermore, we submit that the suspension for the rest of the year is not proportionate to the punishment that the learners is not proportionate rather to the violation of the rule by the learners, my justices. And also, my justices would like to point out, as the respondent said, that the learners were liable for banning of the school. We submit that no culprits were identified by the police, and the respondents cannot just come before the court and say that the applicants are liable for that. And we also like to draw the attention of the court to the facts of the case that they assembled outside the school premises, so they did not touch any school premises. That I would like to put in front of the court. And also, my lord, I would like to point out this important part, that the learners did not give, the respondent argued that the learners did not give.
Sorry, I think your time is up. Sorry to interrupt you.
Yes, my justices, my time is up. I thank you for your time.
Thank you. If the respondents would like to use their 2 minutes for their rebuttal.
Honorable Justices, I would like to reply to the applicants about the issue that they are saying that they gathered outside the school premises. When they were blocking roads, they used the school bins. They used the school bins to block the road and make fire with the rubbish bins that was inside of the rubbish bins of the school. So this makes it clear to the court that the applicants were responsible of it. Honorable Justices, coming back to the consultative process. When I repeat again that when the learners are enrolled on school premises, they had to sign the school code of conduct, which means that they knew that if they don't adhere by the school code of conduct, they will be suspended. So the applicants can't just come and say that it is the code of conduct is unlawful. It is lawful because they didn't raise any issues when the school code of conduct was implemented or ask questions when they were signing the school code of conduct. This makes it clear to the court that the learners understood the school code of conduct. So they can't just claim that they didn't understand it. I thank you.
Okay, thank you very much. I just wanted to ask on your argument now, on saying that the children threw rubbish from the dustbin and created a fire. Are you assuming that? I know one of the justices raised that, but I just want to confirm the position. Are you saying that that's an assumption, or are you saying that that's the facts? And how did you get to that argument?
May you please rephrase?
So my question is, I mean, throughout your argument, you made reference to the fact that the learners, participated in an peaceful protest, but, were there actual facts to come to this argument, or how did you arrive at this conclusion? Because, as far as we are aware, there weren't any, camera footage or any evidence that can justify or back up that argument.
Your Honor, this can be justified if the learners can come to the school and write a written apology and apologize verbally to the school. We don't want more of them. We just want an apology and for them to promise the school that they will never repeat the same mistake they may have done, and promise the school that they will adhere to the school code of conduct.
Okay, thank you very much.
Maybe just for, if you see paragraph 11 of the facts, it says clearly that the students brought out bins and blocked the road and even set fire to it. I think that is where you're not maybe getting the facts clearly. The students were not liable for vandalizing the school property in the building because no culprit was apprehended then, but they were liable for burning the bins on the street, disrupting the movement, the right to movement of others.
Yes.
Right.
Your Honor, according to our Constitution, if
Chief Justice, I think their time is also up.
Yeah, it is. Sorry, it's so difficult over Zoom. But thank you very much for your time, everyone. Well done to the speakers. You both teams, did a very good job, and yeah, all the best with the rest of the competition. If the other justices can just maybe stay behind.
I'm sorry, I didn't get the last thing. Did you say we can make final comments?
Oh, that's what I wanted to confirm. I mean, do we give the comments to the speakers at the end, or is that kind of what we put on those?
We comment to, yes, we comment to the general presentations, no specific comments, because each specific comment will be left in the score sheet. So we just give general comments, yeah.
Okay, perfect. If you want to start, just giving your comments, you're welcome.
Yes. I think I'll just let the speakers know you did well. I mean, you're high school kids. I was not expecting this level of research and understanding of the facts and also the law. So thank you. But also to maybe request that in making your submissions, you do not need permission from anyone. So you constantly stop in to say, Honorable Justice, may I proceed? You do not really need to do that. When you answer a question, you just proceed to the next point, because you're also working with time. And then constantly calling honorable justices. Sometimes I'm like, okay, I can hear you, just continue. So yeah, that also is good. So I wish you all good luck. And I know that, I hope to see you in the next rounds as you proceed in the competition. But you should be proud. So well done. You've done really well.
Justice Webster, I'm not sure if you want to say anything. I don't know if the respondents have left. I don't know.
Yeah, I know the respondents have left. So I'm not sure if we would be doing a good service to then give feedback to only the applicants, but you can direct us.
I think they might be back. 131R looks back. Counsel for the respondents, are you back? We just want to give you a final comment.
Okay, I'll give my comments. Hopefully that they are here. I would like to firstly thank both teams for their preparation. It was clear in terms of the arguments that a lot of work went into preparing for today. So just thank you very much for that. And I guess compliments to yourself and the rest of your team for the work that you did. And I look forward to hopefully seeing you in the next round. So thank you very much.
Okay, thank you, everyone. I think both of the justices did, exactly what I found. And like I said earlier, I wish you all the best with the rest of the competition. Let's see. Do any of you know how to not, remove people out of the meeting? Okay, thank you so much. Just the judge. No, I just wanted to chat to the judges afterwards. So just Webster and Jivan. Yes, please. Sorry.
Are you going to put them in the waiting room or are they leaving? Because I'm assuming that we are done with the session. So I think so, because then you're not going to allow them back in because we should be finished. We should have been finished sooner. So I guess.
Hi, sorry to come in, Joy. I wasn't paying attention. What's going on? What's the question? Can we help?
The judges wanted to have a quick chat, and so the question is whether we can remove everybody from the room and whether they should be put in the waiting area or should they just be removed entirely. So I'm assuming we are done, so they can be removed entirely. So maybe you can confirm, JT.
Okay, you wanted a private conversation as judges by yourselves. It's not about providing feedback to the teams.
No.
Sorry?
Yeah, no, it's just between the three of us that are now the only ones.
Oh, the
party
three of
to the-
you. No, it's
Yeah,
fine. You can proceed to have your discussion.